Hey, how you doing? This is Adam Post. Supreme Court overrules judge. Trump can do deportations under wartime law. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from the Washington Post, Supreme Court lifts hold on Venezuelan deportations to El Salvador for now. What this means is the Alien Enemies Act, the wartime law, and no, there doesn't have to be a war ongoing. There just has to be an invasion or an incursion as declared by the president, not by Congress. And that's what we had with this Tren de Aragua gang brought in by the country of Venezuela. This is a really effective way for the government to locate gang members that are specifically part of this group and immediately send them back to the country that they came from, because they are dangerous. They're even worse than the MS-13 guys. They've also been declared terrorists. And what the administration did was, in their judgment, they considered this to be an incursion or an invasion supported by the Venezuelan government. And they do have evidence to support that. But that decision is a political decision. It's not a decision that a judge can make. It's not even a decision really the Supreme Court can make, but the Supreme Court is not touching that. They're just simply saying, yeah, the federal government can make the distinction, at least at this time, if the country is being invaded or has an incursion by a foreign power. That's not up for some local district judge, whether they're in DC or Florida or Rhode Island or wherever, to judge on their own. This is a major win for the administration. It's also a major hit against these national injunctions. This was not part of a national injunction, but it was part of the judge in DC creating a class, as if this was a class action protecting the Tren de Aragua gang members. The judge did this very quickly and inappropriately, in the opinion of a lot of legal experts, because that's not how you create a class. And in effect, it became like a nationwide injunction against using this law against anyone who was part of the Tren de Aragua gang. The national injunction issue is not resolved, but it's getting closer to being resolved, and it's important because judge after judge in a local jurisdiction who is an activist, who wants to push their political agenda, who is supposed to be responsible for their local geographical area, their cute little town or city, is putting nationwide injunctions against the federal government, preventing the federal government from being able to do normal federal government things. Whether it's immigration or hiring and firing, these local federal judges have really been expanding their powers to the point of ridiculous. But this was a first major test of the issue of, can a local judge make policy and political decisions for the entire country? And so far, the Supreme Court has said, no, they actually can't do that. A divided court said migrants filed their challenge to the Alien Enemies Act in the wrong jurisdiction, but also said potential deportees must get due process. The Supreme Court's decision to let the administration make their own political decisions about the Alien Enemies Act is a major win. They did also say, yes, the people you're deporting need to get some kind of due process. In this situation, due process means give them a chance to say, no, I'm not part of this gang. I don't apply to the Alien Enemies Act. I'm just a nice guy. They can say that, and they are going to get due process. But this is important. They're getting due process in Texas. And Texas is not very friendly to illegal aliens. They have a big problem with that. They also don't really like gang members. What the Supreme Court found is that this case should be happening wherever these people are being held by the government for deportation under the Alien Enemies Act. So in this case, it's Texas, definitely not DC. And there's a habeas court. There's a system for them to go through to be able to say, hey, give me some due process. They'll get it. But they're going to get something very different than a typical illegal alien deportation would get. They will get notice from the federal government, which will probably be in some written form, letting them know that they're about to leave the country under the Alien Enemies Act in about a week or 2 weeks, and that they'll get to appear in front of a judge and make their case. That's if they want to make their case. A lot of people aren't going to even bother making their case. A lot of people who are gang members, for whatever reason, admit that they're gang members anyway, and they're going to just go back. The people that want to make their case, they'll get a chance to make their case in front of a judge, but they're not even automatically going to be given their own attorneys. In Texas, there's no constitutional right to an attorney for a habeas corpus application. The judge presiding over the application does have the discretion to appoint an attorney if they deem it necessary, which is to say it's very different than coming to the country illegally and then getting to get a whole process through immigration courts, having to have an order of removal, having it take a very long time to get those illegal aliens out of the country. The main priority are the dangerous people, whether they're MS-13 or Tren de Aragua or anyone else that might fit in under the Alien Enemies Act. So far, we've really only heard about Tren de Aragua being focused on for the Alien Enemies Act. There are other authorities that can get rid of dangerous aliens and send them back to their countries. But this one is a really expedited process. And in that way, it is a huge win for the government. Also in the sense that the jurisdiction is being set all the way back to Texas, where people are being held. That's another major win, especially because the government, when they apprehend people, can drive them over to Texas or wherever they want to, where the government feels they have the most likely chance of getting past their judge in the due process so they can get people returned to their home country. But the priority here is really the Tren de Aragua gang. A divided Supreme Court on Monday cleared the way for the Trump administration to use a controversial wartime authority to deport alleged members of a Venezuelan gang, but said detainees must first have an opportunity to challenge their deportations. The 5-4 ruling did not touch on the underlying legal questions about the government's use of the Alien Enemies Act, one of the most high-profile and contentious immigration enforcement actions so far in President Donald Trump's second term. They are allowing the government to use the Alien Enemies Act because it's very clear, it's very much in black and white. The determination is a political determination by the administration whether or not we have an incursion or we have an invasion. It's not about a war. And incursion and invasion are part of the statute. It's part of the actual law. The judge can't review that. The Supreme Court can't review that. They don't have the information to review that. That's why we have an executive branch. If the Supreme Court did not want the government using the Alien Enemies Act whatsoever, they would have prevented them from continuing to use it until it was litigated in the lower courts. It's not going to get litigated. The majority of the court ruled that the 5 Venezuelan immigrants who challenged the policy did so in the wrong court, leaving open the possibility that those targeted for deportation could refile their case in Texas or other jurisdictions where they're detained. They need to file their case in Texas, and they need to do that relatively quickly because they're going to soon be put on notice they're about to be deported under the Alien Enemies Act unless they can find a way to extend their case in Washington, D.C. That's just for these 5 people that got this case started, not for the fake class action that was put together by Judge Boasberg in Washington, D.C. The Supreme Court said, quote, the detainees are confined in Texas, so venue is improper in the District of Columbia, and as a result, the government is likely to succeed in the merits of this action. The ruling said detainees are entitled to notice within a reasonable time frame and must have an opportunity to challenge their removal if they choose to, including the government's use of the WARTIME Act, which they can do. But since they're not even entitled to attorneys, some of them may have attorneys, but they're not even all going to have attorneys, it's unlikely that's really going to go anywhere. They're getting detained. They're getting removed under the act. And what's more is, now this is individualized, meaning every individual deportee that wants to make their claim can make their claim and say, I'm not part of Tren de Aragua, I'm a great guy. They can do all that, but it has to be done on an individualized basis, and they have to convince the judge on an individualized basis. Even if one of those people has success and they're not deported under the Alien Enemies Act, that's not going to save anyone else from being deported under that act. The decision appears to take the central legal issues of the case away from Judge Boasberg of the U.S. District Court in Washington, D.C., whose temporary restraining order blocking the deportations prompted impeachment calls from Trump and his allies and triggered a showdown between the president and the judiciary. A showdown which that judge lost. Justice Roberts, Justices Clarence Thomas and Samuel Alito, Neil Gorsuch, and Brett Kavanaugh were in the majority on the ruling. Kavanaugh defended their decision in a brief statement, saying the majority's disagreement with the other 4 justices is not over whether the detainees receive judicial review of their transfers. All 9 members of the court agree that judicial review is available, meaning they can make their case in habeas court. The only question is where that judicial review should occur. It can't occur in D.C., and it can't occur on a class basis. Meaning, literally, you're going to take, 1 million of these guys, or however many of them are, 10,000 of these guys, and have that decision made on behalf of all 10,000 of them? Ridiculous. Of course, this is political because the Trump administration wants to show dangerous criminal illegal aliens, hey, look, we can throw you out of the country. You're not going to be here for a couple of years. And it's supposed to scare off other dangerous people who are not here legally to know, look, you can either go back to your own country or wait until we find you and send you to a prison in El Salvador. One side of the argument is trying to protect the country and threaten people who are in the country doing bad things. The other side is trying to say, well, we don't want to give you a political win, and we actually like having these people in the country because it helps to destabilize society. That's unfortunately the political argument we're having here. The court's 3 liberal justices forcefully dissented because it's bad for their political agenda, joined in part by Justice Amy Coney Barrett. The liberals warned of potential life or death consequences from the majority's order and criticized their colleagues, saying their ruling, quote, flouts well-established limits, creates new law on the emergency docket, and elides the serious threat our intervention poses to the lives of individual detainees. Yeah, but they are declared as terrorists by the federal government. Maybe they should not be in the country. They emphasized that the court's order on Monday means the government cannot again usher any detainees onto planes in a shroud of secrecy and without a hearing as it did on March 15th. Quote, nor can the government immediately resume removing individuals without notice, wrote Justice Sonia Sotomayor, joined by Justices Elena Kagan, Ketanji Brown Jackson, and Barrett. Quote, to the extent the government removes even one individual without affording him notice and a meaningful opportunity to contest a planned deportation, she added, it does so in direct contravention of an edict by the United States Supreme Court. They're going to get a written notice. It's probably going to be 1 week to 10 days out. It's going to say, good luck finding a lawyer if you want one. You're not going to get one provided by us. Then they're going to get marched in front of a habeas judge in Texas, who is going to say, make your case. Are you going to say you're not here as part of Tren de Aragua? You're just here doing what? Explain yourself. They'll get a chance. They'll make their case. That habeas court judge will make a decision. Many of these guys are getting sent back to Venezuela. Trump last month declared the presence of the Venezuelan Tren de Aragua gang in the United States an invasion and invoked the 1798 Alien Enemies Act, which is aimed at removing citizens of a nation with which the United States is at war. The war is not a prerequisite to invoke the act. The government then rushed to deport Venezuelans to a notorious mega prison in El Salvador, using the Wartime Act to justify sending deportees to a country where they're not citizens. It's not like Venezuela wanted them back. D.C. Judge Boasberg halted the deportations in response to a lawsuit filed by the American Civil Liberties Union, which said Trump can't invoke the act to deport Venezuelans because the United States is not at war with the country. It called the president's use of the act unprecedented. Quote, the act was meant solely to address military hostiles directed at the United States, not criminal activity by a gang during peacetime, according to ACLU attorneys who wrote that in a filing. But more than 130 Venezuelans were removed on the same day Boasberg issued his order, without advance notice or a chance to challenge the government's assertion that they're part of the gang. U.S. officials later acknowledged that many of the deportees did not have criminal records in the United States. Because no, you don't actually have to accomplish committing crimes that we catch you for and get to prosecute you for before we'll take you out of the country so that you can do these crimes either somewhere else or not do them at all, but at least not do them in the United States. Government attorneys called Boasberg's block on such deportations while litigation continues an unconstitutional imposition on the president's broad authority to deal with national security issues and conduct foreign policy. They explain the gang is operating in the United States at the behest of Venezuelan President Nicolas Maduro, an idea disputed by some government intelligence agencies that, of course, are involved in politics. Unfortunately, we've yet to see any political or presidential election situation that isn't tied up with our intelligence agencies. At least ever since Trump got involved, but it probably goes back many decades before then. Well, this case presents fundamental questions about who decides how to conduct sensitive national security-related operations in the country, the president or the judiciary. Acting Solicitor General Sarah Harris wrote in a court filing, quote, the Constitution supplies the clear answer, the president. The Republic cannot afford a different choice. Because judges don't have national security advisors. Yes, you can give them a written report. They don't read the president's daily briefing. They're not supposed to. It's not the business of the judges to second-guess the administration on national security or foreign policy issues, or even any political questions. Homeland Security Secretary Kristi Noem celebrated the Supreme Court's ruling in a social media post on Monday night. Quote, President Trump was proven right once again. SCOTUS confirms our Commander-in-Chief, Donald J. Trump, has the power to stop the invasion of our country by terrorists using wartime powers. Leave now or we will arrest you, lock you up, and deport you, she wrote. The ACLU called the justice's ruling that migrants are entitled to challenge the government's claim that they're gang members a huge victory. Quote, we're disappointed that we will need to start the court process all over again in a different venue, but the critical point is that the Supreme Court said individuals must be given due process to challenge their removal under the Alien Enemies Act, according to the ACLU. Justice Jackson got mad. She also wrote separately from other liberals, sharply criticizing the majority for handling a complex matter through the court's emergency docket rather than with the usual lengthy briefing and oral argument. She invoked the court's infamous decision during World War II to allow the internment of thousands of Japanese immigrants and Japanese American citizens, and said Trump is leaning on a centuries-old wartime statute to whisk people away to a notorious, brutal, foreign-run prison. For lovers of liberty, this should be quite concerning. With more and more of our most significant rulings taking place in the shadows of our emergency docket, today's court leaves less and less of a trace, Jackson wrote. But make no mistake, we're just as wrong now as we have been in the past, with similarly devastating consequences. It just seems we are now less willing to face it. A DC court should not be handling habeas petitions for people being detained in Texas. It's absolutely ridiculous. And we should not have nationwide injunctions on political questions. The Alien Enemies Act has been invoked 3 other times in the nation's history and only during wartime so far, including World War II when it was used to hold tens of thousands of people, including U.S. citizens of Japanese descent. A 3-panel judge on the U.S. Court of Appeals for the D.C. Circuit upheld Boasberg's pause on deportations 2-1, emphasizing that it was a temporary decision and not the final word on the legality of Trump's use of the act. Boasberg called the Trump administration's use of the act problematic and concerning. Democracy Forward, which is representing the illegal aliens along with the ACLU, and who loves Tren de Aragua, said the Supreme Court ruling affirms what we've long known. The Trump administration acted unlawfully when it removed people from this nation with no process. But it's not like the prior administration did anything illegal bringing these people in with no vetting and no process. But we're disappointed that the court sought to intervene in this matter at a preliminary stage and before the district court could hear further argument. We will continue to use all legal tools to protect our clients and people across the nation from removal without process. But there is no jurisdiction in D.C. to handle the case. That's another thing the Supreme Court said. D.C. was not supposed to have this case in the first place. There should be no national injunctions or class actions with regards to immigration actions. Not from the judiciary. Maybe politically, but not from these ridiculous local district court judges. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.